Welcome to our newest episode of the UPC Insights podcast, published by Meissner Bolte under the supervision of Tilman Pfrang. We're here today with Niels Schuh from our office in Düsseldorf. Tilman Pfrang is here. My name is Jasper Werhahn. I'm also pet attorney from Munich, and we have attended our first hearing at the Central Division in Paris last week on Friday and wanted to share our first impressions with you. So Tilman, we started the hearing last week, Friday, on a rainy day in Paris at 9:30. You want to share a little bit about the event, how we got there, how the event went for us?
Yeah, sure. I mean, how it went, we will see in the future. The court did not, as they usually do not, they did not announce a decision. This is expected in 6 weeks. Yeah, well, how did it go? We arrived in Paris on Wednesday evening, then spent a wonderful day with our colleagues at Santarelli IP firm. Thanks to our colleagues, by the way. Again, this was very useful that we could prepare our case in kind of a friendly atmosphere of our colleagues of the EPLN network. Yeah, well, then the rainy day started. We walked to to the premises, which was a good idea because traffic was jammed, and I think the taxi ride would have been very difficult.
Yes.
Yeah, and then, well, the oral proceedings started at 9:30. Niels?
From a German perspective, it was pretty unusual. Of course, the court introduced the case, but it was in a very formal way, and you could not hear a real tendency of the court. The introduction was also made by the judge rapporteur, which was also different than in the German proceedings, while we, or at least myself, had the impression that all judges were involved in this matter and were familiar with the case. And then after the brief introduction, the presiding judge invited the parties to plead the matter. And this was, in my opinion, also very unusual from a German perspective, because there was no indication what points were really open and needed to be discussed, which points were fixed. And so it was a very open pleading.
I think that's a very important point, Niels, because we have learned that the Central Division, especially in isolated revocation actions, but also in counterclaims for revocation, is obliged to act according to EPO practice. But this is not to be understood in a procedural way. Of course, they are bound to the rules and articles of the EPC, but the way they handle the proceedings when it comes to validity of a patent in suit is completely different from what we are used from the EPO, as you said, because at the EPO, every single issue will be discussed in detail separately with a short intermission for the opposition division or the boards of appeal to decide on the individual point, and they will come to a conclusion and announce it to the parties. And in this case, we had a very brief introduction. There were also some specific problems in this case about the admissibility of auxiliary requests, and neither the patentee nor we got any indication about the board's opinion or the division's opinion on the question of the admissibility of the requests. So it wasn't even clear whether we should plead against the numerous requests on file or whether this was simply something superfluous because they would not consider these requests anyway. So it was a very open discussion, which made it very difficult, I think, Tilman, to plead before the division.
Yeah. Well, let's say difficult, yes. I would say, on the other hand, not unreasonable. It's another style a little bit to the EPO, where we have more this Q&A format. I must say also that style, however, has its benefits. I mean, it's not like in the EPO where sometimes one very detailed aspect within the Q&A session is discussed in all length for several hours, and then you see, oh no, it's 5 in the evening. We have 99 other points to discuss. This I have much sympathy for. I have to say. I mean, it's difficult for the pleadings, of course. You must be prepared to have a pleading for 1 or 2, or in bigger cases, maybe even 3 hours, I could imagine. And when you must prepare it accordingly, it's not enough that you just know very well the case, then the facts of the case. You need to be prepared to have a kind of a speech.
I think this is a very important aspect, that you need to assure that the court can follow your line of argumentations. We prepared it and so that not one person pleaded all the way through the hearing. On the other hand, if one person will plead for 1.5 hours in the same style, it's very hard to follow through the facts and the argumentation. So if one person alone will plead, he has to assure that he has some other possibilities to draw attention to the main points.
Yeah, I fully agree. And it was also a good practice we basically took turns pleading, which also gave the person presently not pleading the chance to double check whether all the arguments were really present. And also the person not pleading had the opportunity to really watch the reaction of the division, and if necessary, to add on or emphasize certain points that maybe didn't come across in full.
Yeah, well, so far, I mean, the intention of this podcast episode is more that we that we share our first impressions of the case. We will have anyway maybe also a bit longer episode next time with our new moderator George. So I would say, Niels, Jasper, do you have anything to add for the moment?
It was a very interesting experience, and it was very interesting to see, since it was only one of the first few hearings at the Central Division in Paris. There was a kind of anxiety on both sides of the division as well as the parties. It was quite interesting to watch, and I look forward to the next oral proceedings in Paris.
And then we can tell how we even found the place.
Yes.
which was maybe the most difficult part of all.
Yes.
that we will discuss with George. And thank you both. And
thanks for having me.
until next
Thank you,
time.
Tilman.
Yeah.
See you soon.